Welcome to this explainer. Today, we are setting the stage for a completely new era of legal efficiency in Mexico. We're demystifying the newly minted General Law of Alternative Dispute Resolution Mechanisms, or as we'll call it to save our breath, the LGAMSC.
Think about this for a second. What happens when traditional courts are no longer your only path to justice? For decades, right, legal disputes have almost universally meant long, drawn-out, and honestly, really expensive courtroom battles. But we're reframing all of that today. We're going to look at this new law not as some strict mandate you've got to memorize, but as a much-needed, highly efficient menu of faster out-of-court options. So here's our roadmap. 1. A new judicial era. 2. The new rules of the game. 3. The step-by-step procedure. 4. Final agreement requirements. And 5. Jurisprudence and human rights. All right, kicking things off with Section 1. A new judicial era. Before we get into the granular details, we really need to understand the big-picture context of this legislative milestone. First things first, let's break down the core acronym we'll be using throughout this explainer so we're all on the exact same page. AMS. It stands for Alternative Dispute Resolution Mechanisms. Simply put, these are efficient extrajudicial tools. Basically, they're ways to solve your legal problems without ever having to sit in front of a judge in a traditional courtroom. And that brings us to a massive milestone for modernizing the Mexican justice system. On January 26, 2024, this new law was officially published in the official Diary of the Federation. It formally recognizes, strengthens, and regulates these alternative mechanisms on a national scale. It's a huge shift, going from seeing mediation and conciliation as just fringe options to placing them right front and center in the legal landscape. Moving right along to Section 2, the new rules of the game. Let's see exactly how the playing field has expanded for legal professionals and everyday citizens. So, the law introduces 5 absolutely massive changes. First, the scope is vastly expanded. We aren't just talking about minor neighborly disputes anymore. This covers civil, mercantile, family, and even administrative conflicts. Second, we've got brand new institutions like administrative justice centers to support the process. Third, there is now a national platform of facilitators, which makes finding an accredited professional incredibly easy. Fourth, the law demands stronger certification and training for these facilitators, guaranteeing high professional standards. And finally, all of this adds up to greater accessibility to justice for citizens who can't, or let's be real, simply don't want to endure a traditional trial. Lawyers now have a much broader toolkit to actually resolve their clients' conflicts. Okay, Section 3, step-by-step procedure. We know the what, so let's shift to the highly practical how. How do you actually use this fast lane? The initiation process is beautifully straightforward. Step 1 under Article 63 is the request. You literally just provide your general data and the contact info for the other parties involved. That's it. Step 2 under Article 66 is admission. The facilitator receives your request and evaluates if the conflict can legally be solved this way. And here is the absolute best part. If your case isn't admitted, the facilitator is legally required to let you know by the very next business day, so no waiting around for months just to hear a no. Now, the way these meetings are structured shows off the incredible flexibility and fairness built into the process under Article 71. The facilitator can host joint meetings where everyone is at the table together, but, if the situation is tense, they can totally hold separate meetings. However, the law demands strict fairness here. If I meet with a facilitator separately, you absolutely must be informed that the meeting happened, even though the exact content remains completely confidential. And you have to be offered the exact same opportunity to meet separately. It keeps the playing field perfectly level. Once the actual sessions get going, Article 74 sets the ground rules. Generally, all parties must be present, either personally or through their legal reps. But what if your dispute involves some really complex financial or technical details? Well, the law actually allows you to bring specialized experts or appraisers right into the sessions. The only catch? Every single party has to agree to it, and whoever asks for the expert has to foot the bill. Which brings us to Section 4, Final Agreement Requirements. You've requested the mechanism, you've had the meetings, and you've found a solution. Now we introduce the crucial end goal of the entire MASC process, the binding final agreement, or the convenio. Article 94 lays out the rigorous requirements for this final agreement. The law itself lists 10 pretty dense, specific things you need, but don't worry about memorizing them right now. We're going to logically group them up to make them incredibly easy to digest. First up, we have the foundational administrative requirements. These are the basics you need to make the agreement totally legitimate. You need the place and date, the full personal details of everyone involved, a unique folio tracking number, and if a corporation is involved, proof of its legal existence. But most importantly, you need crystal clear clauses detailing the exact obligations, who is giving what, doing what, or not doing what, along with the specific time and place for compliance. Then, we get into the more complex requirements. The crucial point here is how the law ensures ironclad enforceability and protection. You need signatures, or fingerprints, with a witness and an official ID if someone can't sign. Now, if the agreement involves the rights of children or teenagers, it legally requires an extra validation signature from a public center, which is a strict, absolutely vital rule to protect minors. It also must explicitly state what happens if someone breaks the agreement and exactly how a judge will enforce it. Finally, the facilitator has to attach their name, certification number, and signature, backing the integrity of the whole shebang. And finally, Section 5, Jurisprudence and Human Rights. Let's look at the why. We need to anchor all these practical steps we just learned in some heavy constitutional weight. Because, guys, these aren't just polite suggestions. They are fundamental rights. According to the jurisprudence, Article 17 of the Mexican Constitution dictates that the law must privilege the will of the parties to use these alternative mechanisms. It's actively encouraging you to solve things yourselves. But importantly, taking this path doesn't mean you're ever renouncing the jurisdiction of the state. It's simply meant to be a preferred first step. And this next part is a massive point of reassurance for anyone who might be a little hesitant to try this out. If you initiate a MASC process, but for some reason one party misses a meeting or the whole process just breaks down, you do not lose your right to formal justice. Exploring this fast lane option doesn't legally trap you at all. If mediation fails, the traditional courtroom is right there waiting as your robust backup plan. And that brings us to one of the most powerful statements in modern Mexican law. According to jurisprudence TMX 2157-684, access to alternative dispute resolution mechanisms as a human right enjoys the same dignity as access to the jurisdiction of the state. Choosing a facilitator over a judge is definitely not a lesser form of justice. It's not second class. It's a fundamental human right carrying the exact same dignity and weight as a formal trial. Which leaves us with this final thought. We've seen how the new LGMASC expands your options, speeds up the timeline, ensures total fairness, and backs up your agreements with the full weight of the Constitution. You now understand the incredibly powerful tools available to you. So, the question is, are you ready to resolve your conflicts without ever stepping foot in a courtroom? Thanks for joining me for this explainer. Keep learning, and I'll catch you in the next one.